Good afternoon, ladies and gentlemen. Welcome to Bexar County Court of Law number 6 and the Bexar County Veterans Treatment Court plea docket. I'm Judge Wayne Christian. It is approximately 2:10 p.m. on Thursday, the 9th of September, 2021. The cases we have set today are for pleas. Cause number 663-750, State of Texas versus Henry Castaneda Bravo, represented by Judge Joanne De Hoyos. Cause 645-687, State of Texas versus Karina Wood, represented by Mr. Ivan Barrera. Cause number 662-767, State of Texas versus Clarissa Beleza, represented by Ms. Sunny Middleton. Cause number 650-783, State of Texas versus Danielle Dolishall, represented by Ms. Elizabeth Russell. We have a Bexar County Veterans Treatment Court Track 1 pretrial diversion plea and probation agreement. Cause 652-883, State of Texas versus Jasmine Samuels, represented by Mr. Ivan Barrera. We have a Bexar County Veterans Treatment Court termination hearing, cause number 633-867, State of Texas versus David Juarez, represented by Judge Joanne De Hoyos. And we have a motion to modify bond conditions, cause 667-883, State of Texas versus Jonathan Milburn, represented by Miss Loretta Hewitt. Is Miss Hewitt here at this time? Loretta here yet? No?
No, Your Honor. I think we told her about.
Good. That was the whole point. Okay, Judge Joanne, can you hear me?
Yes, Your Honor, we're present. Ready.
Are you still under a time constraint? Because
No.
we need to do the Spanish plea first, and I would like to put off Mr. Juarez termination hearing after 4 other pleas if you have time to do that.
No problem. No problem.
Okay,
That's fine.
great. Okay, let's start with cause 663-750, State of Texas versus Henry Castaneda Bravo, represented by Judge Joanne De Hoyos. And we have an interpreter, and the interpretation is working and everybody can hear. Is that correct?
That's a victory for today already.
Okay. Yeah, exactly. All right. Mr. Henry Castaneda Bravo, I have one document for you to identify for me at this time. It is entitled Defendant's Consent to Plea by Video Conference, which purports to have your signature on it and your attorney's signature on it. Mr. Castaneda Bravo, is this your signature on this document, sir? I'm not hearing the interpreter. Am I supposed to be?
Not hearing either.
No,
No.
no.
Speak.
Thank you. And Judge Joanne, as attorney for Mr. Castaneda Bravo, is this also your signature on this document?
It is, Your Honor.
Thank you. Mr. Castaneda Bravo, I have one other document for you to identify your signature on. It is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Castaneda Bravo, is this your signature on this document also?
Sí.
Thank you. By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, Judge De Hoyos, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Sí.
Thank you. And for the record, we also have actually 2 documents. One is in English and one is in Spanish. And Mr. Castaneda Bravo, is this your signature on both of these documents?
Sí.
Thank you. Judge De Hoyos, as attorney for Mr. Castaneda Bravo, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
I have, and he is, Your Honor.
Mr. Castaneda Bravo, are you a United States citizen, sir?
No.
Mr. Castaneda Bravo, if you are not a citizen of the United States of America, a plea of guilty or nolo contendere for the offense charged may result in your deportation, your exclusion from admission to this country, or the denial of naturalization under federal law. Have you discussed with your attorney and been made aware of the mentioned consequences? And are you now still knowingly wanting to enter a plea to this offense?
sí,
Judge De Hoyos, as attorney for Mr. Castaneda Bravo, did you have the ability to discuss with him the possible problems he may encounter with regard to his immigration status if he enters a plea to this crime?
Yes, and if I may further, Your Honor, he also has an immigration lawyer that approved and reviewed the offer. And so we have had that done also.
Okay, so your understanding is that Mr. Castaneda Bravo is willing at this time to enter into a plea bargain with the state on this case. Is that correct?
Yes, yes, Your Honor.
Fair enough. And Judge De Hoyos, has the state fully complied with discovery for you on this case?
They have, Your Honor.
And let's see what we're doing here. State, have you got a motion on this case?
Yes, Your Honor. The state moves to waive and abandon the 0.15 enhancement paragraph and proceed on the Class B DWI.
No objection from?
No objections, no.
That will be granted. Therefore, Mr. Castaneda Bravo to the charge of driving while intoxicated, first offense. How do you plead, sir?
culpable,
Is there an agreement for Mr. Castaneda Bravo?
There is, Your Honor. 6 months Bear County Jail, probated over 12 months, $500 fine, court cost, 48 hours community service, DWI education, victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile for half the term, restitution, if any, to Isaac Mendez Martinez, and restitution, if any, to Daniel Matthias.
Is that your understanding of the agreement, Judge De Hoyos?
It is, Your Honor. And if I have further, Your Honor, I noticed that I told you he was going to do this again. This is the third time he's appeared for this docket, so any consideration of community service would be appreciated. He had issues with interpreter last time.
There's no objection, Your Honor.
I just assumed there were a lot of different people in the Castaneda Bravo family. I did.
Rhea, yes, he's been, this is the third time before him, so I kept hoping that nothing would happen this time. We're all praying.
Okay, let's make sure I get this straight. Mr. Castaneda Bravo, on cause number 663-750, the court accepts your plea of guilty to the offense of driving while intoxicated, first offense. I find you guilty. I assess 6 months in the Bear County Jail, probated for 1 year, a $500 fine plus court cost, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, restitution, if any, to be paid to Isaac Mendez Martinez and or Daniel Matthias, and Smart Start Mobile Home Interlock for 6 months times 4 blows a day. I'm going to probate all his community service because we pretty much used up that 48 hours dragging him back and forth to our 3 or 4 hearings. Fair enough.
Thank you, Your Honor.
Anything further from the state of the defense on Mr. Castaneda Bravo?
Now, we thank the court for all the appreciation for all the time it gave us.
Okay. Good luck, Mr. Castaneda Bravo. Thank you, Judge Joanne. Okay.
gracias.
Judge, is he going to Susan now, or what does he do? Does Susan go to
Okay,
take him?
now, Mr. I don't know if you'll interpret. Mr. Castellano, the probation department will contact you in 48 hours. If they do not contact you, you have to call them. I would say if you haven't heard by Tuesday morning, call, and I'm going to give you a phone number to call. So do you have paper or pencil so you can write something down?
Mm,
Joanne?
sí, un segundito.
Okay.
Segundo.
Now, anyone that,
Sí, dígame, por favor.
okay. Okay, the phone number is 210-335-7446. So if you do not hear from them by Tuesday morning, call. Okay,
Por favor, repítalo otra vez. Disculpe.
sure. It's 10-3-3-5-7-4-4-6.
7-7-4-4-6. Los cuatro últimos, correcto.
Okay? All
Thank
right,
you.
thank you. Now, anybody that is being granted probation,
Correcto.
it is the same thing. You will be contacted within 48 hours. If not, you need to call probation, and y'all need to be aware of that phone number. I'm going to put it in the chat so all of you can look at it and get time writing it down. Okay, Judge.
Okay, batting order at this time is going to be cause number 662-767, State of Texas versus Clarissa M. Beleza, represented by Ms. Sunny Middleton. Cause number 650-783, State of Texas versus Danielle M. Dolishall, represented by Ms. Elizabeth Russell. Cause number 645-687, State of Texas versus Karina G. Wood, represented by Mr. Ivan Barrera. And our Bexar County Veterans Treatment Court Track 1 pretrial diversion plea and probation agreement. Cause number 652-883, State of Texas versus Jasmine Joy Samuels, represented by Mr. Ivan Barrera. Ladies and gentlemen, I have one document for you to identify your signature on for me initially. It is titled Defendant's Consent to Plea by Video Conference. Ms. Beleza, and cause 662-767. Is this your signature on this document, ma'am?
Yes, sir.
Thank you. Ms. Middleton, as attorney for Ms. Beleza, is this also your signature on this document?
Yes, Your Honor.
Thank you. Ms. Dolishall, and cause 650-783. Is this your signature on this document?
Yes, Your Honor.
Thank you, ma'am. And Ms. Russell, as attorney for Ms. Dolishall, is this also your signature on this document?
Yes, Judge.
Thank you. Ms. Wood, and cause 645-687. Is this your signature on this document?
Yes, Your Honor.
Thank you. And Mr. Barrera, as attorney for Ms. Wood, is this also your signature on this document?
It is, Your Honor.
Thank you. And cause 652-883, Ms. Samuels, is this your signature on this document?
Yes, Your Honor.
And Mr. Barrera, as attorney for Ms. Samuels, is this also your signature on this document?
It is, Your Honor.
Thank you. The next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions that purports to have each of your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Ms. Beleza, is this your signature on this document also?
Yes, Your Honor.
Ms. Dolishall, is this your signature on this document also?
Yes, Your Honor.
Thank you. Ms. Wood, is this your signature on this document also?
Yes, Your Honor.
And Ms. Samuels, is this your signature on this document also?
Yes, Your Honor.
Thank you. By signing these documents, are each of you telling me that you've had enough time to either read these documents or have them read to you in their entirety? If you had any questions about what was on these documents, those questions were answered to your satisfaction by your attorney. So that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Ms. Beleza?
Yes, Your Honor. Sorry, I was trying to hit the mute button.
No problem. Is that correct, Ms. Dolishall?
Yes, Your Honor.
Thank you. Is that correct, Ms. Wood?
Yes, Your Honor.
Thank you. And is that correct, Ms. Samuels?
Yes, Your Honor.
Thank you. As attorney for Ms. Beleza, Ms. Middleton, have you had enough time to go over this case with her? And in your opinion, is she mentally competent?
Yes, Your Honor.
Same question for attorney for Ms. Dolishall, Ms. Russell.
Yes, Judge.
Thank you. Same question for attorney for Ms. Wood, Mr. Barrera.
I have and she is, Your Honor.
Thank you. Same question for attorney for Ms. Samuels, Mr. Barrera.
I have and she is, Your Honor.
Ms. Beleza, are you a United States citizen, ma'am?
Yes, Your Honor.
Thank you. Same question for Ms. Dolishall.
Yes, Your Honor.
Thank you. Same question for Ms. Wood.
Yes, Your Honor.
Thank you. Same question for Ms. Samuels.
Yes, I am. Yes.
Thank you. Attorney for Ms. Beleza, Ms. Middleton, has the state fully complied with discovery for you on this case?
Yes, Your Honor.
Same question for attorney for Ms. Dolishall, Ms. Russell.
Yes, they have, Judge.
Thank you. Same question for attorney for Ms. Wood, Mr. Barrera.
State's complied, Your Honor.
Thank you. Same question for attorney for Ms. Samuels, Mr. Barrera.
State's complied, Your Honor.
Okay, let's see what we're doing on Ms. Beleza's case. State, you got a motion on Ms. Beleza's case?
Yes, Judge. The state moves to waive and abandon the enhancement paragraph and proceed on a Class B DWI.
No objection, Your Honor.
State's motion to waive the 0.15 greater enhancement. No objection from the defense is granted. And let's see, that brings us down to DWI first. Therefore, Ms. Beleza, on cause 662-767 to the charge of driving while intoxicated, first offense. How do you plead, ma'am?
Guilty.
Your paperwork says no contest. I don't think it matters to me or the state. Ms. Middleton, do you care?
No, Your Honor.
Let's just say no contest for purpose of the record unless state objects, because that's what my paperwork says.
Okay, no
Objection,
contest. Sorry.
Judge.
Court accepts a plea of no contest to the offense of driving while intoxicated, first offense. Is there an agreement for Ms. Beleza?
Yes, Your Honor. 6 months, Bexar County Jail, probated for 16 months. $850 fine. We ask the court to probate $350 of this fine. Court cost 48 hours of community service, DWI education, VIP live, cat snip, Smart Star mobile device for half the term, regular UAs, and pay restitution, if any, to Bernardo Martin and Enriqueta Martinez. The amount is to be determined, Your Honor.
Okay. And Ms. Middleton, is that your understanding of the agreement?
Yes, Your Honor.
If they come back and they say they want $2.5 million and y'all don't think that's the right amount of money, we can of course have a hearing on that. So we take care of that. And the two alleged victims, Martin and Martinez, correct? Two different names.
Yes, Judge. Should be Bernardo Martinez and Enriqueta Martinez, Judge.
All right, so Martinez, M-A-R-T-I-N-E-Z is the last name for both parties?
Correct.
Okay, that's what I was afraid of. Thank you. Okay, let's make sure I get it right. Ms. Beleza, on cause 662-767, the court accepts your plea of no contest to the offense of driving while intoxicated, first offense. I find you guilty. I said 6 months in the Bexar County Jail, probated for 16 months, $850 fine, probating $350 of that plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, Smart Start mobile home interlock at 4 blows a day for 8 months, which is 1/2 the term. Regular urinalysis tests, restitution, if any, to Bernardo and Enriqueta Martinez. Anything further from the state or the defense on Ms. Beleza?
No, Your Honor.
No, Your Honor.
Good luck, Ms. Beleza. Thank you, Ms. Middleton. Y'all are excused.
Thank you, Your Honor.
Ms. Beleza, do you understand all that probation stuff they rattled off to you earlier?
Yes, I already have the number down.
Great, appreciate it. Thank you.
Thank you. Thank you, Your Honor. Y'all have a good day.
You bet. Okay. Let's see, Ms. Doleshaw to the charge of criminal mischief, $750 to $2,500. How do you plead, ma'am?
No contest.
Is there an agreement for Ms. Doleshaw?
Yes, Judge. This will be a judgment satisfied. So the agreement is $150 fine, court costs, 97 days in Bexar County Jail, credit for time served, time and money to run concurrent, judgment satisfied.
Is that correct, defense?
Yes, Judge.
Is 97 days the amount of time that Ms. Doleshaw has in jail on this case?
I believe so, Judge.
Okay.
Not on
Technically,
this
Judge,
case.
yes. So it's not on this particular case though, Judge. So She was released on bond on this case in late November, rearrested in December, and then released in early March on the new case. A warrant and an increase in bond was never ran on this particular case, Judge, during that time.
All right. All
So
good.
did she have another case? Because what I show in the system for this case is only 1 day.
That case was dismissed.
So for the record, Judge,
And so this matter.
it appears the defendant was in jail from November 19th, 2020 to, and she was released on that same date. And also, Judge, she was in Bexar County Jail from December 7th, 2020 to March 12th, 2021 on a DWI third and ABI family violence second,
Okay.
Judge.
Then I would suggest that you give him, what you give at least the judge the information, the cause numbers on those so that she gets that credit, because we only show 1 day. And so you're going to need to give the judge those cause numbers, and the judge has to say, I guess, he's willing to accept those.
How many other cases are we talking about? 2 or 3?
Well, Judge, as of today, this is the only open and pending case
That's
that I
not what
see in
I'm
Bexar County. I can give you the DWI third case number.
All right, give me that one. That's good.
So I see 2018 CR 8338. Does that sound about right, Ms. Russell?
Well, an MTR was ran on that case, but the new the new case was 2020 CR 29, I'm sorry. Let me get the right one. Give me just a moment. It was Night Mag number 594544. So
All right.
that's the case that she was arrested on December 7th, Judge, and then released on March 3rd.
All right, for purposes of the record, we're trying to clarify where the state and the defense have come up with this 97 days of jail time. So the jail time originally incurred in cause number 6500783 is going to run concurrent with 2 other cases, 2018 CR 8338 and Night Mag 594544, for purposes of jail time that was utilized by the state and the defense to come up with an appropriate sentence on this case. Is that accurate, state?
Yes, Judge, and I believe that the Night Mag that you just mentioned, I believe that belongs to a family violence case, but that case was dismissed, Your Honor. So the state has no objection if the court wants to.
She could have spent a lot of time in jail and still had the case dismissed. That's kind of the way that works sometimes. All right, so everybody's happy, and it's going to be a JSTAT, so we're good to go. Okay, thanks, Ms. Doleshaw. You're released. Thank you, Ms. Russell.
Thank you, Judge.
Thank you.
Okay, you bet. And Ms. Wood in clause 645687. Let's see what we're doing. And this is originally the DWI first, right? We're not reducing anything. The charge of driving while intoxicated, first offense, Ms. Wood, how do you plead?
No contest, Your Honor.
An agreement for Ms. Wood in 645687.
Yes, Your Honor. 16 months deferred adjudication, $500 fine. We ask the court to prorate $100. Court costs, DWI education, VIP, CAT SNP, 48 hours of community service restitution, regular UAs, Smart Start mobile device for half the term, and pay restitution, if any, to Mason Polanco and Rebecca Gonzalez. The amount is to be determined.
And is that correct, Mr. Burrow?
It is, Your Honor. Just 2 things on the restitution. I did provide the state with insurance documents that all claims were paid out. And in addition to that, Judge, my client did try to apply for the BTC. She is a veteran, but she didn't qualify. So I was wondering if we can do anything with the community service hours.
Great, thanks. What'd you do in the military, Miss Wood?
I was a pharmacy tech, Your Honor.
Ah, thank you. Thank you for your service.
Thank you, Your Honor.
Okay. In cause number 645687, the court accepts Ms. Wood's plea of no contest to the offense of driving while intoxicated first offense. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt, place you on 16 months deferred adjudication and probation, assess a $500 fine, probating $100 of that, plus court costs 48 hours of community service, probating all of that based on your military service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile Home Interlock at 4 blows a day for 8 months, which is 1/2 the term, regular urinalysis tests, and restitution, if any, to Mason Polanco and Rebecca Gonzalez. Anything further from the state of the defense on Ms. Wood?
No, Judge.
Good luck,
Nothing
Mr.
from-
Wood. Thank you, Mr. Barrera, on that one.
Thank you, Judge.
Thank you, Your Honor.
Ms. Wood can get out of here if Mr. Barrera wants her to, but Mr. Barrera's got to hang around for one more plea.
Yeah, Karina, I'll call you after.
Okay, this is cause number 652883, State of Texas versus Jasmine Joy Samuel. This is a Bexar County Veterans Treatment Court, Track 1, pretrial diversion, plea and probation agreement. And Ms. Samuels, to the charge of driving while intoxicated first offense. How do you plead, ma'am?
Guilty, Your Honor.
Is there an agreement for Ms. Samuel?
Yes, Your Honor.
Yes, Your Honor.
Oh, no, I know what it is. It's the same one we always use on all track one,
Yes.
right? Okay, I've got you.
Track 1.
It's been a long day. I'm sorry. Court accepts your plea of guilty. Hold it in abeyance. Place you on 1 year. Bexar County Veterans Treatment Court, Track 1, pretrial diversion probation. Assessing a $1,000 all-inclusive veteran treatment court fee. 48 hours community service, probating all that based on your military service. And DWI education, DWI victim impact panel. 6 months Smart Star Mobile Home Interlock at 4 blows a day. Outpatient drug treatment with either the Veterans Administration or a designated VTC provider. No restitution on this one, hopefully. Let's see.
No, Your Honor, I don't believe so.
Great. Successful completion of the Veterans Treatment Court, issue judge's bond, defendant to be supervised by CSCD and VTC staff. At this time, Ms. Samuels, I'm looking at a document entitled Application, nope, try again. Track 1, pretrial intervention, which is a contract by and between you and your attorney in the Bexar County Criminal District Attorney's Office. Said contract setting out all the prerequisites and requirements for your successful completion of the Veterans Treatment Court. In fact, ma'am, is this your signature on this document?
Yes, Your Honor.
And Mr. Barrera, this is either yours or one of your law partner's signature on this thing. Let's see what we got. Mr. Salazar's signature. Would that be Mr. Salazar's signature, who is in your firm, Mr. Barrera?
That's correct, Your Honor.
Okay. We've got Miss Samuels now. We got her on contract. Okay, what did I miss? Josh, Ron?
Got it, Judge.
All right. Miss Samuels?
Judge.
Yeah, go ahead.
One thing, Miss Samuels turned in the VIP certificate, so if we can show that she's getting credit for that.
Great.
And she stated she is already registered for the DWI education course.
Great. So she proactive credit for the victim impact panel. And Miss Samuels, what'd you do in the military, ma'am?
Information technology, Your Honor.
Were you Army, Air Force?
I was in the Army.
All right.
Yes.
It was our Army, yours and mine. Did you have a chance to go over to the sandbox and play that game?
Yeah, I went to NTC.
All right. Thanks for your service, ma'am. Anything further from the state of the defense on Miss Samuel?
Nothing from the defense, Judge.
All right. Thank you, Miss Samuels. And
Thank
thanks,
you,
Mr.
thank you.
Barrera. Y'all are out of here.
Thank you, Judge.
Okay. I've next got, anybody need a break? Or are we ready to continue on Mr. Juarez's case?
I believe state's ready, Your Honor.
Okay. This is cause number
I'm ready. I'm sorry. It was taking me a minute to get on.
633-867, State of Texas versus David Juarez. This is a State's notice of termination of pretrial intervention, which states, for the record, now comes Joe D. Gonzalez, Criminal District Attorney of Bexar County, Texas, by and through the undersigned Assistant Criminal District Attorney, and respectfully request the court to set the above entitled and numbered criminal action on the court's docket for the following reason. The defendant has violated the terms of the Veterans Treatment Court program. As a result, the pretrial intervention program and participation in the Veterans Treatment Court have been terminated. Wherefore, premises considered on this second day of September 2021 is requested that the above entitled clause be set on the court's docket. Respectfully, Megan Galloway, Assistant Criminal District Attorney. So that being said, my records reflect that Mr. Juarez was accepted into the Veterans Treatment Court under Track 1 pretrial diversion back on, it's like March 30th, 2021. Does that sound right? Anybody got a different plea date? Sometimes we date these things earlier than we actually do them.
He pled in on April 1st, Judge.
Okay, so that was his original entry into the VTC.
That's correct, Your Honor.
Okay. And apparently the charge that he pled no contest on was discharging a firearm in municipal population of a city of greater than 100,000 people, which is a Class A misdemeanor in the state of Texas. And who is his probation officer? Mr. Bonneblust?
Yes, sir.
Would you please advise the court and the parties of the status of Mr. Juarez's probation?
As of right now, Judge, Mr. Juarez has completed his anger management course. He's completed the education test. As far as community service, I'm not sure if we're going to give him credit for it. He's paid to date $350, and he has a remaining balance of $654. He's still pending the gun safety course, alcohol awareness, and the remaining $654 as for his fees. As far as treatment, he's been attending treatment. He's been meeting with his doctor regularly. I know Miss Cho is out today, so I'm not sure if there's any updates on that because I haven't received anything. But other than that, he picked up the new charge out of Shirts on 8/24, and that charge is deadly conduct.
Does anybody know specifics? I mean, are they saying he pointed a gun at somebody, or what are they saying the deadly conduct consisted of? Do we know?
Your Honor, the allegation is that Mr. Juarez shot a firearm up into the air.
Oh, okay.
About 4 times.
Okay, so I mean, there's no one victim like I pointed a gun at somebody and he said he pointed a gun at me. He shot a gun.
Yes.
Allegedly, he shot a gun in the air. Is that kind of what we did the first time too?
That's correct, Your Honor.
Officer Bonnebless, can you report to the court about the UA that was taken on 8/25?
Yes. So right after the arrest and after I received notification that he was arrested, I spoke with him on 8/25. I had him submit a UA just to make sure that to see if there was any alcohol in his system. He informed me that there was no alcohol and that it would not come out dirty. I did receive those results and it was positive for alcohol.
Okay, Judge Joanne, what do we got?
Your Honor, I talked to my client and he disputes that he had any alcohol. He says he doesn't know how that happened. I believe he took another drug test, correct? And that was fine. He took another one.
Yes. Yes. The following week, since he was placed on weekly UAs, that one has returned back as negative.
My client was asking if in fact you're going to take him out, that he'd be given credit for any time he has on. I'm not sure if you had him on Scram yet, but he could not afford Scram. And give credit for his anger management. I thought his community service was all probated, Joe, because he's a veteran.
Is the
yes,
because he said something about community service, so I wasn't sure what that was about. Okay, and he would like the monies paid goes towards any fine or court costs the court will be assessing. My client has had a lot of issues. Obviously, he denies and the allegation. He had some issues with the police officer, stopping him for no reason. So that's something for his lawyer to deal with his Shirts. I'm not even sure when that's going to happen. We were staffing this and then the positive came in. My client says he has no idea how that came out positive, and that's his position. I don't know if he wants to say anything. I told him he could have an opportunity to tell the court if he wanted to stay in the program. And Mr. Juarez, have you decided if you want to stay in the program or you just want to be on regular probation? You're on mute, sir. Can't hear you. You're mute.
Sorry about that. If I could, I would love to stay in the program.
And to what efforts are you going to do to do that? I mean, you said you just, you tell this team, tell the court, what is it that's going to change?
I'm going to complete everything this month. I'll complete my gun, firearm safety course. I'll probably be able to pay off more of the money. I'll start working on my alcohol treatment. I'll do it whatever it takes. I'll stay on scram, put the device on my car, whatever y'all want me to do. I'll be willing to do it.
You had inquired about some mental health issues or issues with, you already taken your anger management course, correct?
Yes, ma'am.
You willing to do that over? I mean, obviously there was some episodes in the past report about you getting into it with a police officer. Can you explain what your thinking was about that?
I should have been thinking more clear. I'm gonna be honest. I did have alcohol in my system. It wasn't as much as I thought. I thought it wouldn't show in a UA, and it did.
And that's the problem we have here. We've told, and the judge has said this to every veteran, it's better to come clean than be caught. I mean, that's one of the first times you ever said that. And I think the court and the staff has to hear that. I mean, this is your life. I mean, you can think you can beat drug tests. Welcome to all my clients. They say the same, you know?
Is the new case in County Court 6? Do we know?
No, it's in Shirts, but I don't think it's going to come in for a while. The police officers, yeah.
But
the report hasn't come in from the police department that I could tell.
is it going to be in Bexar County, part of Shirts?
Yeah, I don't.
It would be in Guadalupe County.
I don't think so. Yeah.
Hey, do you have any insight on that one, Megan? I guess
it would be in Guadalupe County, Your Honor, not Bexar County.
Okay, I got you.
That's what we said. It'd take forever for them to do anything. Even before the pandemic, it took forever.
All right, we're in sort of an unusual circumstance because we have an old offense and a new offense, which looks kind of like the old offense. And obviously, Mr. Juarez has the absolute right to remain silent and not say anything about the new offense. And we've got his lawyer present. However, that's one of the key issues in my mind on what exactly happened. And I'm not real excited about shooting in the air. I know it's dangerous and stuff, but we're not shooting at somebody. You know, we're not robbing a bank. We're not shooting out stoplights. We're shooting in the air. I don't know why anybody would want to do that, but Judge Joanne, do you want to go have a brief chat with him? I'm going to want him to tell me what happened that day. And he obviously has a complete right not to talk about it. And I understand.
I already advised him to remain silent, Your Honor.
Okay.
Yeah, I don't think that'd be, you were on YouTube. I don't think that'd be wise for him to do that.
And what did Mr. Juarez do in the military? Hey, sir, what did you do in the military?
Field artillery, Your Honor.
You Army, Marines, what were you?
Army.
Did you go to the war?
No, Your Honor.
Where were you stationed?
Hawaii.
Oh, you kept Al Qaeda out of Hawaii for us. Thank you for that. How many years were you in the military?
A little over 3.
Okay. What kind of discharge did you get?
Honorable.
Okay. Give me a couple of minutes to do a little writing here. Mr. Juarez, the court accepts your plea of no contest entered on or about April 1, 2021. Well, first off, let me go back up a second. I'm going to grant the state's notice of termination of pretrial intervention, signed and dated as of this date. I'm going to accept your plea of no contest to the offense of discharging a firearm in a municipal population in a city in excess of 100,000 people, which was previously held in abeyance. I'm going to now accept it and find you guilty of the offense of discharging a firearm in a municipal population of a city greater than 100,000 population. Sentence you to 1 year in the Bexar County Jail, probated for 6 months, assess a $500 fine plus court costs, 48 hours community service, probating all that based on your military service, a PSE course for stress management. Let's do a Smart Start Mobile at 4 blows a day for 3 months, which is half the term. If he does well, we come off of that. Weekly UAs, if he shows me 4 clean weekly UAs in a row, we'll take him off of weekly UAs. What other requirements did he have with us? I'm not going to do the gun safety course. Did he do an alcohol awareness course for us at some point? Was that the VTC treatment he did at with the VA, I'm guessing?
He hasn't completed the alcohol awareness just yet.
Is that at the VA, or where is that being held?
Let me see.
He was referred to the VA after the incident and after the positive UA. However, that was not a part of his original plea deal.
All right. Let's say this again. Mr. Juarez, it cost 633,867. Court accepts your plea of no contest rendered on April 1st, 2021 to the offense of discharging a firearm in a city with a municipal population greater than 100,000 people. I find you guilty. I says 1 year in the Bexar County Jail, probated for 6 months, a $500 fine plus court costs, 48 hours community service, probating all that based on your military service, APSE course, Smart Start Mobile, home interlock at 4 blows a day for half the term, which is 3 months. Weekly UAs, show me 4 clean weekly UAs, I'll take you off of that, put you back on monthly. And the Community Alliance for Traffic Safety New Intervention Program, which is our outpatient drug program. All of which is a whole lot more fun than a year in the Bexar County Jail. Anything further from the state of the defense on Mr. Juarez? He's now on regular probation in Bexar County County Court at Law number 6.
Your Honor, yes, he's already paid some fees. Could he get credit for that?
He gets credit for every dollar he's paid, any community service hours. We waived all his community service hours.
And I think he's already done the anger management, correct? Mr. Waters, you already done that, correct?
If he's already done that, he gets credit for it, certainly.
All right, let's make sure.
Anything he's done or paid, he gets credit for.
And he'll have to call the probation department if they don't call him by Tuesday.
Probably, I don't know, Joe, I don't know whether you will do it. What I'm going to be doing, Mr. Juarez, is I'm going to be sending you a probation application and a new data sheet that you're going to have to sign. Do it as quickly as you can. I'm sure that the probation department will probably be contacting you within 48 hours. If not, you need to contact them.
Mr. Waters, did you write down that number?
Did you write it down, Mr. Waters?
Not yet. Let me get a piece of paper. Okay.
The phone number is 210-335-7446. So if by Tuesday you have not heard from probation to set up orientation, you need to call them by Tuesday morning. Okay?
Yes, ma'am.
All right, and I'll send that paperwork in just a little bit.
Okay.
Thank you, Honor.
Juarez, just so you know, if you hadn't come clean on that your analysis test most recently, you'd be reporting to the Bexar County Jail first thing Monday morning. So, and ask Judge Joanne how that works. She knows me very well, and she knows I would put you in jail in a heartbeat if I felt like that's what you deserve, but you were honest with us. So I want you to know that we all appreciate that. It came a little late, but it still saved you from going to jail. So you're back on probation. If your biggest problem in life is you got a conviction for shooting a gun in the air, you're doing okay. All right.
Yes, Your Honor. Thank
Thanks
you.
for your service, sir. Thank you,
Good
Judge.
luck, Mr. Juarez. Good luck.
Thank you.
Can I be excused?
You bet. Thanks so much.
Thanks.
Your Honor, Miss Hewitt is
Talk to
here
you later.
with her client. I'll talk to you.
Okay.
And the only thing was, I did not know whether Mr. coming in, they have not signed a defendant's consent for hearing by video conference, Your Honor. If you want me to send it, I can, or you can do it orally.
It doesn't bother me. State and or Ms. Hewitt, do you really care? I think technically we're supposed to have a defendant's consent to hearing by video conference form signed. I don't really care, but if y'all want to waive it, that's okay with me. State, you willing to waive it?
Your Honor, if they could just waive on the record, please.
All right, fair enough.
Yeah, certainly.
Thank you so much.
Are you ready to proceed, Ms. Hewitt?
I think so.
Let's see what I got here. Okay, this is cause number 667-883, style of State of Texas versus Jonathan Milburn, excuse me. And this is a motion to modify conditions of bond. Ms. Hewitt, would you go ahead? Well, before we get into that, normally we use a defendant's consent to hearing by video conference document in writing that is signed by all the parties. In this particular case, it is my understanding that both the state and the defense are willing to waive that on the record and are not required for purposes of this hearing only. Is that correct, state?
That's correct, Your Honor.
And is that correct, Ms. Hewitt, for the defense?
It is, Judge.
Great. So waived. Okay. Ms. Hewitt, would you please advise the court and the parties of what you are requesting in your motion to modify conditions of bond?
Yes, Judge. All we're asking is that the condition of no contact with the complainant Stormy Custer be changed to no harmful and or injurious contact. Mr. Milburn does not wish to maintain a relationship with Miss Custer, but they do have two children together, a 10-year-old and a 5-year-old, that he wants to, and before this incident, there was no reason to have a custody agreement in order, so there isn't anything that I'm aware of. He is in the process of hiring a family law attorney to get one in place, but the big concern, Judge, is several-fold. I've spoken with Miss Custer, and I'll relay to the court the concerns about that in a moment, but it's my understanding that the children that Miss Custer has either already or there's a very good possibility that she will be taking the children out of Texas if they are not out of Texas already. She married someone who lives in Washington State in 2019 and is still married to that person. But these two children are Mr. Milburn's children. And he wants to be able to communicate with her simply about the children. I had a very strong conversation with him, which he will agree with, that he is not to violate this no contact order. So he has attempted to contact her extended family to see if there's a way to work something out as far as communication with the children, but they will not respond. My understanding from Miss Custer and my client is that the 10-year-old has a phone that she can use to communicate with my client. However, she's on a kid's plan. I don't know the exact term. And his number has either been excluded, blocked, or not added yet. So he cannot communicate with his 10-year-old. Miss Custer told me that the kids are technically already out of the state. When I asked for clarification, she would not tell me what that meant. And she also told me that she is using this situation with the kids to make a point with the defendant. So we are very concerned about where those children are and want him simply to be able to communicate about that.
when I spoke with her, I was trying to suggest something like guardian house or some, just to find out her feelings was the reason I called her, so I didn't misrepresent anything. And I couldn't have a straightforward conversation with her about that. So that's what we're asking for right now. And I don't know if she is actually out of the state already. I believe she is still here, but we have very good reason to think the children have been removed from Texas.
Okay, well, first off, we have limited jurisdiction over any kind of family law matter involved in this case. It's strictly on the civil side.
I only tell that to the court to give you an understanding of his.
Wasn't there original argument that the incident stemmed from about the children pretty much, or she was going to move back to town or move back for the husband or something? And wasn't that the original argument issue, basically?
Yeah, that was a big part of it.
Well, I mean, just from what you've told me, just from the defense side, it just sounds like if I open up the floodgates and let Mr. Milburn contact her, they have nothing to do but argue. I mean, he's mad at her because she's hiding the kids from him. I don't blame him for being mad at her. But, you know, them talking about it is not going to help matters from my perspective. What do you think?
Well, she has already been in contact with him, and he has not responded because I've told him under no circumstances to do that. And she has she's confirmed with me that he is not contacting her. But she's already texted him and tried to communicate with him about the children and telling him, don't worry, I'm going to let you see the kids. But he can't communicate back with her per my advice and the court and the no contact order. He just wants to be able to communicate with her because she is initiating contact with him about the children.
Okay. In your conversations with Miss Custer, is that correct? Custer?
Yes.
Okay. Did she indicate to you that she wanted you to ask the court to allow her husband or the father of her children to contact her and talk to her about kids? Did she give you any insight from that angle?
Well, that's when she told me that she is using the kids, to make a point to Mr. Milburn. So that's the only answer I got from her.
Okay. Let me ask of the state, Ms. Galloway, did you not contact the victim, the alleged victim in this case, with regard to her wishes on this contact order business?
Yes, Your Honor. So for the record, the state is opposing the change to the no harmful. Your Honor, I did have my own conversation with Ms. Custer, and she did not express to me that her or the children were living outside of Texas. She did not state that. And she did iterate to me that she has been in contact with the defendant's mother regarding the children. So Ms. Hewitt claimed that she had not been letting him see the kids, but Ms. Custer did state that she has been in contact with Mr. Milburn's mother in regards to the children. Well, the mother. And I would just like to reiterate that the reason that they were arguing was because Ms. Milburn stated she was undecided whether she was going to move out of the state or not, and that is what led to the physical assault of her by the defendant.
Ms. Hewitt, did you, when you were having a conversation with Ms. Custer about the children, did you inquire of her whether or not y'all could arrange some visitation with Mr. Milburn through KidShare or one of those type organizations?
I tried to have that conversation with her, and she was not able to maintain a civil conversation.
What is the status of who is the primary conservator of the children at this time? Is there any kind of order out there that talks about that?
That's what I mentioned at the beginning. There was no reason to have that before. He is in the process of hiring an attorney. The other thing, Judge, I would add is that the DAs gave us a plea bargain agreement last week where it included their willingness to change. One of the conditions was a no harmful or injurious contact with Stormy. So that it's our position that they're using that. They're willing to change it to no harmful or injurious if he takes a plea bargain, which is completely inappropriate. So I don't know why they would be opposed now. Your Honor, that plea agreement is the state would agree to a no harmful or injurious if the defendant was placed on community supervision to be supervised by the court, complying with other conditions, going to classes, and working on issues that relate to this offense. It is my position that there has not been a sufficient cooling off period as of this date. This offense occurred a little over, the offense date is August 21st, 2021. Your Honor, it has not even been a month since this offense occurred. And in my opinion, there has not been a sufficient cooling off period. And the no harmful or injurious contact term of the plea bargain has absolutely nothing to do with this hearing.
It has everything to do with it, Judge. If we would have told her that we were going to take that plea bargain the next day, the state was fine with it. It's completely relevant. So now that they are opposed to it, only if he doesn't take a plea bargain is ridiculous.
Well, it's not unusual in these circumstances for the state to make an offer like that, knowing if the defendant is under community supervision, and if I'm his judge, if there's a problem, he's going to have a major bad day. But if that's
I've
not
explained
there, then
that.
he's not, obviously.
I've told him that he's going to have a bad day because he's going to be under your jurisdiction if he violates that no harm.
All right, here's what I suggest at this point in time. A, we all want Mr. Milburn to get visitation with his kid. And I hate to say this, Mr. Milburn, it's going to cost a lot of money to hire a family law lawyer to file an initial custody. I don't know, it would be custody battle. It would just be basically a establishment of parental rights type case, but that's still going to cost several $1,000s probably. I don't know if Ms. Hewitt does those things or not. You might talk to her about that. But in the interim, if either Ms. Hewitt or Ms. Galloway talk to the mother, you might tell the mother from me that I would like her to allow visitation in some capacity through Kids Share. I am not going to change the order today. I can change it tomorrow if things change, but the victim is not, or the alleged victim is not really saying she wants to talk to the defendant that I'm aware of. I mean, either side get that inference from the mother, Ms. Custer? No.
Well, only from her text to the defendant, and clearly not, because she's told me she's using this to make a point to the defendant. So she's using the kids against him.
Okay.
Your Honor, and I would like to state that it is the defendant's burden to not respond to the complainant. The complainant does not have a no contact order to abide by.
And he hasn't responded. That's what I've said. And she confirmed that.
I understand. Ms. Hewitt, here's my ruling, basically. I think if I open the floodgates and allow Mr. Milburn and Ms. Custer to continue on like they did before the argument that resulted in us being here with this case being filed, we're going to have another case being filed. So in the interest of safety of everybody concerned and not wanting any more problems for Mr. Milburn than he already has, he needs to stay cool. He needs to talk to family law attorney and proceed that way. But either of you, either Ms. Hewitt as the defense counsel or Ms. Galloway as a DA, if you talk to Ms. Custer, or if you choose to call her and tell her what I'm telling you, I want Mr. Milburn to have visitation with his kids. And I don't know that Ms. Custer doesn't want that either, but it has to be without them talking to each other or seeing each other. It has to be through Kids Share or some other one of those type circumstances. So,
well, she hung up on me after she was not able to have a civil conversation. So I'll leave that to Ms. Galloway to contact her.
And Your Honor, I will do that.
So if you would, Ms. Galloway, chat with the mother and tell her that I'm keenly concerned about the fact that the father needs visitation in some capacity. And I would say once a week for, I don't know, 3 hours, 5 hours, whatever. I don't think there are any allegations Mr. Milburn is any problem at all with his kids. So anything she's willing to allow her over the weekend, anything like that would be probably okay with Mr. Milburn. The more time, the better. Is that not correct, Mr. Milburn?
What was that you cut out, sir?
Yes, sir. The more time you can have with your children, the better you would like it. Is that accurate? I mean, get them for a weekend or something. You'd be happy to do that. All right.
Yeah, no problem.
There are no allegations whatsoever that you're going to be any danger to anybody other than the mother of the kids, kind of deal. So
Mr. Milburn has never been arrested before in his life. So
I understand.
Your Honor, Mr. Milburn does have a juvenile theft case.
Oh,
All right, well, we're not gonna worry about all that today. Stay
Yeah,
calm, stay
juvenile.
cool. All right. I want to make crystal clear. I want Mr. Milburn to see his kids, but I do not want him to have contact with the mother of the kids until the time is right, and that time is not today. So Ms. Hewitt, feel free to re-urge your motion anytime. I'm leaving it open. That's the way I'm ruling today. I'm not gonna write stuff down. It's just gonna be on the record. So the motion today, or the order of no contact whatsoever is still in effect. She will probably try to contact you again, Mr. Milburn. That's the way this always works. At that point, you need to contact your attorney and ask your attorney to call her back and explain to her that you cannot have personal contact with her. You know, if she requests to have it reduced from no contact whatsoever to harmful, injurious, then I'll be happy to re-listen to this. But that's kind of what we need to have happen.
Could we have or I'll contact the court in, let's say 2 weeks or so that there's a timeline for her to be contacted and set this up. I'll go through Pat to make sure that it's done in time.
You're on standby, Ms. Hewitt, until you get back with me. How's that?
10-4.
And Your Honor, Mr. Milburn is set for this coming Tuesday. Would you prefer that we reset it to make it 2 weeks?
What is he set for? Arraignment?
Yes.
All right. At this point in time, I think, Ms. Hewitt, you're willing to waive arraignment, and you can set this for a jury trial, which pushes you back to October. I don't want to make you guys keep coming back and forth because obviously you can't agree. And the worst case scenario, we'll have a jury trial in October. If that's what we need to have.
Or November or December or.
We'll get it on that track. Yes.
When the DA can fly the witness in from Seattle or wherever she's.
Right. I will send you the new date for the jury trial, and that way take you off of the docket for next week, Ms. Hewitt.
Perfect. Thank you so much.
Do we have any other restrictions on Mr. Milburn other than a no contact order right now that are any problems?
Not that I'm aware of, no.
Okay. All right. Everybody stay in contact with your attorneys, and somebody just try to get Mr. Milburn some visitation. And obviously I don't have the authority to order that, but perhaps persuasively we can get that going before they leave. All right. Thank you.
Very good. Thank you.
Thank you.